Hello, I'm Emma, with Vortex REI. If you've recently lost a loved one and inherited a home in Oregon, you may be wondering what happens next. Do you need to go through probate? Does the trust allow you to sell the property immediately? Or could the estate qualify for Oregon's Small Estate Affidavit process? These are some of the most common questions we hear from families, successor trustees, and personal representatives. Today, I'll walk you through the differences between trust administration, formal probate, and Oregon's Small Estate Affidavit process so you can better understand your rights, responsibilities, and options. This video is provided for educational purposes only and is not legal advice. Every estate is different, so consult a qualified Oregon probate or estate planning attorney for advice specific to your situation. Let's begin with the first question. How do you know which process applies? If the deceased person placed the home into a properly funded revocable living trust before passing away, the successor trustee generally administers the trust according to its terms. Oregon's Trust Code, found primarily in ORS Chapter 130, establishes many of the trustee's fiduciary responsibilities. If the property was owned individually and not transferred into a trust or another form of ownership that avoids probate, the estate may require formal probate under Oregon probate law, primarily found in ORS Chapters 111 through 116. Some smaller estates may instead qualify for Oregon's Small Estate Affidavit procedure under ORS Chapter 114, which can simplify the transfer process if statutory requirements are met. So what are the biggest differences? Let's start with legal authority. In a trust, the successor trustee receives authority from the trust document itself once the original trustee dies or becomes incapacitated. Buyers, title companies, and financial institutions typically request documents such as a certification or affidavit of trust, along with other supporting documentation, to confirm the trustee's authority. In a formal probate, the personal representative receives authority only after appointment by the probate court. The court issues letters testamentary or letters of administration, which establish the personal representative's legal authority to act on behalf of the estate. For a small estate affidavit, authority comes from the properly completed and filed affidavit, provided the estate satisfies Oregon's statutory eligibility requirements. Next, let's talk about fiduciary responsibilities. Whether you're serving as a successor trustee or a personal representative, you're acting as a fiduciary. That means you're legally required to act honestly, prudently, and in the best interests of the beneficiaries and the estate. Your responsibilities may include protecting estate assets, maintaining insurance, paying legitimate debts and expenses, keeping accurate financial records, communicating with beneficiaries, and distributing assets according to the trust, will, or applicable Oregon law. Trustees also have specific duties under Oregon's Trust Code, including duties of loyalty, impartiality among beneficiaries, prudent administration, and keeping qualified beneficiaries reasonably informed. Now let's compare court involvement. Trust administration is generally handled privately without ongoing court supervision, which often allows for greater privacy and flexibility. Formal probate, on the other hand, is supervised by the probate court. Certain filings become part of the public record, and the court oversees many aspects of the administration process. A small estate affidavit is typically much simpler than formal probate, but it still requires careful compliance with Oregon's statutory requirements. How does this affect selling an inherited home? A successor trustee may often sell trust-owned real estate if the trust authorizes the sale and all legal requirements have been satisfied. A personal representative may also sell estate property, but the authority and procedures depend on the probate process, applicable Oregon law, and sometimes court approval. Regardless of which path applies, buyers and title companies will want documentation confirming that the individual signing the purchase documents has the legal authority to transfer ownership. Another important consideration is creditors. Both trustees and personal representatives should carefully evaluate creditor claims before distributing assets. Oregon law establishes procedures and timelines for handling valid claims against an estate. Distributing assets too early or failing to properly administer creditor issues could expose a fiduciary to personal liability in certain circumstances. What about timelines? Trust administration often moves more efficiently because there's usually less court involvement. Formal probate generally takes longer due to required notices, court procedures, creditor periods, and other statutory requirements. A small estate affidavit may offer a faster alternative for qualifying estates, although eligibility depends on the value and composition of estate assets under Oregon law. Let's also discuss costs. Trust administration frequently involves lower administrative expenses because court supervision is limited. Formal probate often includes court filing fees, attorney's fees, personal representative expenses, publication costs, and other administrative costs. However, every estate is unique, so actual costs vary based on complexity. One mistake we frequently see is people assuming they automatically have authority to sell an inherited home simply because they're named in a will or because they're a family member. In reality, legal authority depends on whether the property is owned by a trust, requires probate, or qualifies for Oregon's Small Estate Affidavit process. Taking action before confirming your legal authority can create delays, title issues, and unnecessary legal complications. If you're unsure which process applies, gathering the trust documents, will, death certificate, and current property records is an excellent first step before making decisions about the property. At Vortex REI, we believe informed decisions lead to better outcomes. We work alongside homeowners, successor trustees, personal representatives, heirs, title companies, and attorneys to help families understand their real estate options. Whether you decide to keep the property, list it with an agent, or explore selling directly, our goal is to provide transparent information so you can make the decision that's best for your family's circumstances. If you have legal questions about administering an estate or trust, consult an experienced Oregon probate or estate planning attorney. For additional educational resources about inherited property and Oregon real estate, visit vortexrei.com. If you found this video helpful, please subscribe to our YouTube channel so you don't miss future videos designed to help Oregon homeowners make informed real estate decisions. Thank you for watching, and we'll see you in the next video.